All right, let's roll, nerds. Good morning.
Good morning, Judge. I have an off-docket matter.
Okay,
You've asked to be here today. It's, I'll give you a cause number when you're ready.
give it to me.
2500939.
Come up, Mr. Douglas.
I'm inside.
Oh,
And if I can explain a bit to the court.
first things first, though, is I have Mr. White that's been representing him,
Right.
and I guess, did I grant your motion withdrawal, or we're having a hearing now?
We come back on Monday.
All right, so come on up.
So Will reached out to me on Wednesday. I spoke with Michael on Friday. I spoke with Michael on Wednesday. And so basically the understanding is that Will's gonna sub in and take over and I guess
Are
possibly
you
resolve the
hiring
case for
on?
today.
I'm hired on to this new felony
Okay,
case that triggered this whole deal. I've agreed to sub in on this case to work out whatever's going on here, and I've been talking to Michael about that. The felony case is bogus for a lot of reasons, but talked to the state about this as well.
well, hold on.
Okay.
Putting the cart ahead of the horse.
Okay.
So you went out.
Yes,
Okay,
sir.
you're out.
Okay. And I'm in.
Well, I don't know.
Okay.
Want me to appoint him a lawyer, or do you want to?
I'm taking it pro bono because I'm hired on the felony and we want to just resolve this DWI deal today, probably.
Well, because here's the deal. I'm putting him in jail. You picked up a felony while you're on bond for a DWI. You're not supposed to pick up any new cases. You've now picked up a felony and injury to a child, and it's just now coming to my attention, even though this thing's from November. I'm revoking your bond. It goes with you.
Okay.
Let's talk.
May I be excused, Your Honor?
Please.
Thank you.
Thank you, Mr. White. You did file a motion to withdraw, correct?
I didn't.
Mr. White,
He didn't file it.
Aaron,
I thought you
did
did.
you file a motion to withdraw?
Yes, I filed it last week.
Yeah, I saw it.
I don't have it on this one.
He said last week.
Yeah.
It's on Douglas.
Oh, I just see an appointment form from January.
I see the motion to withdraw. Yeah, it's there. Do you see it, Seth? Do you need a cause number?
Yes.
I have the 2500939. Oh, no. Okay.
Yeah, can you put it in the queue so I can sign it? Okay, all right. Tell me. It does,
I know.
look, there's a certain standard.
I
You pick
understand.
up an injury to a child. I don't know anything about the case. All I know, he's picked up a third degree felony, and it's a serious charge. It's not like it's a
But, yeah.
trespass, but it's, so,
But you know that these charges can be
I,
empty.
but I don't know that for sure. All I know is that he's picked up a felony. He's not done squat while he's on bond for this thing. He's literally been riding free, not doing anything for the last 4 months, 4.5 months.
Has he been blown in?
Nothing,
Nothing?
done nothing. He's not tested. He's not had, he's literally done nothing. So
Okay.
anyways,
State's offered a time served. I talked to Michael about it. I'm like, hey, my plan coming in was to try to get him back on PTI
I think
because
they're like,
the felony is so ridiculous. It blows my mind. But regardless, I was talking about that this morning. He's like, honestly, Will, he's like, the PTI it's not feasible for me to do. He's like, is there any other alternative?
if you want time, take it maybe a day.
I don't need the time. He wants to time serve it today, Judge.
Well, if that's what he wants to do, then that's on him.
Okay. Would the court accept that?
Yeah,
Okay.
absolutely. I mean, look, far be it from me to, because that's what we would do in every case.
Right.
Any case that comes back here. And I mean, obviously, state, you need to also be happy as well, right?
Yes, Your Honor.
But it's on you guys. So I'm on board if they're on board.
Okay. I will run it by him just to make sure and then we'll get paperwork started. Thank you, Judge.
So just so you know, you're not here alone. Your lawyer is here with you on Zoom. Ma'am, you were placed on probation in this court in 2022. We've had many, many issues Our first motion to adjudicate was filed, it appears, in November of 23. You were placed back on probation. It looks like a new motion has been filed in February for a variety of things. A warrant had been issued, and I guess now you're here with us. I just don't know how to go forward.
That's why.
Stop. Don't need you to.
Just listen,
right.
please. Don't say
Just
anything.
understand that, now it's not time to fight the case. The only thing that we're dealing with now is the motion to revoke, the underlying issues. And what I see is that you're still testing positive for illegal drugs. I don't know how to go forward, but I don't want to set you up to failure, to set you up to fail as well. So what we do is we have something that's called a TRAS, where I have you evaluated by clinicians to see what is the best way to go forward, because I just don't know. The last thing I want to do is just start pleading people guilty here, left and right, and just end up with, conviction after, no. So the idea is that you leave better than you came. It still hasn't happened. So we need to find out how that's going to happen. So I'd like to please set up our TRAS. Your bond is set now at 10,004. So I have to take you into custody because of the warrant. So I will try to get it done as quick as possible. We could probably have a TRAS done. Do you think maybe tomorrow?
She'll probably still be in processing tomorrow, but by the end of the week.
Okay, we'll try to have it done by the end of the week. They will give us guidance on how to move forward, because I just don't know at this point. The only thing I'm going to tell you is please be honest, because if I get it and it says that there's no issues and it's rainbows and gumdrops, and I know it's not true, and we're going to do it right over again. Okay. Okay. So she goes with you. Okay. Thank you, Mr. Bernie.
And Your Honor,
Yeah.
if possible, can we try to get the TRAS done by Thursday so she could be in court Friday? Because I'm out all
I will.
week.
I'm going to try. So the problem is, though, is that what takes a lot of the time, Brock, is the processing, because we're taking her in now. It's nearly 11 o'clock. They'll probably still be processing her early into tomorrow. If she's still in processing, they can't get it done. Maybe in the afternoon, tomorrow afternoon, they can get it done. I would say probably the latest, today's what, Tuesday? Maybe the latest is Thursday to try to get it done. And then we can try to get the results by Friday.
Okay.
And that's.
Put it on the
if
docket
everything
for Friday?
goes- Yeah,
Can
hopefully.
we put it on the docket for this Friday, Your Honor? Like I said, I'm out all next week. I don't want her to.
So because she's in processing, because she'll be processing now, she will auto-populate on tomorrow's docket.
Okay,
And we can put her on for the Friday. So I
Sounds
can't
great.
really put her on for Friday yet because she'll auto-populate for tomorrow. But tomorrow, then I will put her on for Friday.
no problem. And can you consider reducing the bond somewhat, Your Honor?
No, this is our third case within the last two years. We've had multiple MAJs. I mean, she's doing what she wants to do, and that's it.
I understand, Your Honor.
Thanks, Brock.
No problem. I will see you Friday.
Okay, I'll reach
Have
out
a
to
good
you tomorrow because she'll pop on tomorrow's docket, so I'll reach out to you tomorrow regardless.
Yes, Your Honor. Thank you.
Okay, thanks, bud. Good morning, Mr. Goff. The reason that we took you into custody now is because you were on deferred for an aggravated assault of a family member. It looks like that's in warrant status now and no bond, actually. With us, you've picked up a possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 5th, 2025, at approximately 11:50 p.m., an officer observed a vehicle parked in a handicapped parking space with no displayed license plate or placard, and then leave the parking lot. The vehicle had expired registration as of July 2024. A traffic stop was initiated. The defendant was the driver, and he was ID'd by his Texas ID card. The officer observed the strong odor of marijuana emitting from the vehicle, and the defendant admitted to being in possession of several small plastic bags of marijuana under the driver's seat. A probable cause search was conducted, and 4 bags were located under the driver's seat, 0.154 ounces.
All right, Mr. So he doesn't have a license, correct?
His driver's license is eligible, Your Honor.
Mr. Goff, I'm going to find that there's sufficient probable cause to go forward with the case. I'm not putting any conditions on your bond now. Just behave. That's all I'm asking you to do. You know, you're on felony probation. You're supposed to have a halo over your head, you know? When you don't, bad things happen, as you now see. Can you go ahead and appoint him a lawyer now? So I'm going to appoint you a lawyer so that you can speak to someone. We'll take you into custody now. You'll probably hit felony court Monday, and then we'll just give you a reset of like a week or two to figure out what happens. Okay? All right, man. Good luck.
If you'd be willing to give,
Ordered you not to use, you're now testing positive for cocaine. That's unacceptable. No, I'm not going to let you go. You know, I mean, you know, marijuana, alcohol. No, you're testing positive cocaine. Unacceptable. I order you not to use. Now I have to take further action to ensure that you're not using. First, I'm going to revoke your bond. You go into custody.
Judge, would you allow her to do a walkthrough bond?
No,
If she-
I need you to realize that we mean business, that when we tell you not to use, especially cocaine, you're not to use. I'm sorry.
Would you
Goes with
set
you.
on that, Judge?
$5,001.
5,001. And Judge, I have two more. I have Enrique Flores.
Enrique Flores, come up.
And Judge, on this one, he was in lockout since March 6th. He missed a recalibration appointment. He was working in San Antonio. He does construction work. He didn't know he had that recalibration appointment. He's no longer in lockout. And so I think it was just an issue. He did not know he had that recalibration appointment, Judge.
This is not a burst bond violation with him missing.
I think it might be the second, Judge.
Judge, yes, this is the second. The first one was for the same thing.
Take your time, no rush. Deputy, ain't you going? We need your help. No? Did we let him go the first time?
Yes, Judge.
We didn't take him into custody the first time?
No, Judge.
Unacceptable. He now goes with you. No?
What would you set his bond at, Judge? 5,000?
What's the last name again?
Flores, Judge?
Yeah, 5,002.
5,000.
Yes. Good morning, Mr. Wolf.
Good morning, sir.
Sir, you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On March 7th, 2025, Officer 1 was dispatched to check by a unit at the 3800th block of Breville Street regarding a minor crash. Officer 1 made contact with Officer 2, who on-viewed a two-motor vehicle accident. Officer 2 observed the defendant operating a silver Ford minivan and crashed with a black Hyundai Santa Fe. Both drivers were moved to a gas station. The witness observed the defendant driving the silver minivan and stated she observed the defendant crash into her. The officer observed the defendant to have bloodshot, glossy eyes and sluggish speech and poor balance. SFSTs were administered, 6 out of 6 clues on the HDN, 5 out of 8 clues on the walk and turn, 3 out of 4 clues on the one-leg stand. The defendant was placed under arrest and read the DIC, and he consented to provide a blood specimen.
It's not back.
No.
Prior to the just one from with us or any more?
It looks like there is a pending DWI from Galveston County from back in 2021.
Can you please confirm whether that is actually pending now? Because I'm going to have big issues if that is actually pending. Please. I'm going to find that there's sufficient probable cause to go forward with your case, Mr. Wolf. I'm ordering you now. Just take a seat for me in the jury box. I'm not ready to go forward. I want to know if you have an open DWI. I have found that there's probable cause to go forward with your DWI second in here. You also have another DWI in another county. Stop.
Okay, that was driver not
Stop.
license.
Stop.
Yes, sir.
I don't want you to say anything. I will appoint you a lawyer today, but it's unacceptable that you continue to pick up cases here, there, everywhere. Unacceptable. And I don't think that a PR bond is the right thing to do. I'm now going to revoke the PR bond and he goes with you. You're a danger to our community. That's unacceptable.
Just drive on.
Stop. I will appoint you a lawyer. I don't want you to say anything now. I would like to talk to a lawyer. Can you appoint someone, please? You are not to drive at all. I don't care what you're going, what you need to do. Do not drive. The only thing I'm asking you to do is please don't kill someone on our roads. That's all I'm asking you to do, man. Every single day, we have an intox man, an assault that happens because of this.
Fantastic.
Stop. There is probable cause to go forward. We have trials to determine that, but I have found that they're sufficient to go forward. You've got multiple cases open in another county. Goes with you. I will appoint your lawyer. You tell your side to the lawyer, and then we can talk after. You're saying it is an open DWI in Galveston.
Did speak to the clerk, they said it was not a DWI, yes. And I double checked, and I wasn't as much speak to the prosecutor because they were.
Yeah, I get it. No, I get it. But if you've been able to verify with the clerk over there that he has an open DWI second there and now a DWI second over here, no, 20,000.
2501?
20,000. So when was the first time we tested him?
I believe February the 13th. I'm sorry, not the 13th. It was 2 weeks ago.
2 weeks ago. I have a note from the 10th saying that he tested positive for THC. We were just awaiting to see confirmation from the lab.
The lab confirmation is not on that.
When did we first test him, Lisa?
Judge, 1 second, please.
When was the first, we ordered him not to use when he first got here, correct? This case has been on docket for 64 days and you've continued to use. I have ordered you not to use. You just tested positive. You first came here 64 days ago. I ordered you not to use and you tested positive yesterday?
Sorry, Judge, it's loading.
Take your time.
I have positive on January 17th and then a positive on 3/10.
He was, I understand the test, but my client's very comfortable with me and he was quite confused as to how the results came up positive because
I can tell you why. Hey, I'm revoking your bond. You're going into custody. It goes with you. I told you. So here's what we'll do. We'll give it a couple days. I'll admonish him. Let him out. And clean out. If he cleans, great. If he doesn't,
he goes back in. Can a couple days be like Wednesday?
I'm okay with Thursday.
Okay.
Yeah, for sure.
And for Baptiste, I had filed a motion to withdraw in your queue.
Is he his own land?
Huh? No, he's not on docket. But he doesn't have an attorney, so I don't know if the court wants to appoint. I'm just like,
I don't see him in the docket today.
oh, he's not. I'm just.
No. So we got to get him on the
Oh,
docket.
he's on the docket. Then
Right. I don't just grant because I've done it, granted, and the defendant gets here. Where's my lawyer? I just gave him
Got
money.
it. Okay, that makes sense.
So
On docket,
take
okay.
whatever you want and then we can do
All right, thank you.
it. Hold on, Josh. I've got a lot of people that have been waiting for. Jillian,
Yes, Judge.
are you ready?
Yes, I am.
I know you've been waiting patiently, so let's get you done so you can be done.
Yes, okay.
What are we doing? I don't
So
remember.
Miss Taylor got drug tested.
What's the last name?
Taylor,
Oh, Taylor.
Adrena Taylor.
Yeah. Lisa.
THC, Judge.
So
Come on,
Judge,
Taylor.
we are set for trial in 3 weeks.
I mean.
We're very
you
close
know
to the
what?
end here.
No using means no using. You're on felony probation for aggravated assault. You picked up a DWI. You tested clean in December. Now you're testing 30 again.
No, December? No.
Yes.
The judge,
No, just on the 7th. No, sir.
can we verify? I remember when pretrial services spoke originally, she might have been talking about a different Taylor.
Yeah.
Talking about Adrena Taylor?
Yes, Adrena Taylor, I have her testing clean in November 11th, and that was the only test we had. And then THC confirmed by the lab judge.
Right.
Confirmed by the labs on the 14th.
This March.
Yes, Judge. And then another positive today.
And positive today again.
Still,
She goes with you.
mistake, Your Honor. It will not happen again. I'm gonna
Does
lose my job.
She is there with her parents.
Your Honor, please. It won't happen again.
You're on felony probation. I've ordered you not to use. Now you have a DWI. You tested positive twice.
But I wasn't driving in the DWI. My car was just
So
sitting.
don't say anything
My
about
lawyer
that. Ms.
Talk about
Taylor.
the case with you now.
Ms. Hawkins.
Yes,
Goes with you.
Oh, God. Hold up, take my baby, Your Honor. Please, I need her. I'm sick. Please, Your Honor. No, please. She didn't. Oh, God. Oh, God. Oh, God.
so she takes care of her dad, Judge, of her parents.
Hold on, I'll try to get some help.
She's got a lot on her plate.
I'm sorry.
Lord, I love you. I know you're gonna keep her, Your Honor. I do, but God,
Ma'am, I can have you talk to the lawyer, okay?
please, please.
I'll have her reach out to you guys here momentarily, okay?
I need her, child. I need her. I'm sick. I need her.
Jillian, I'll give them your number.
Alfred Brown? I heard that.
Okay, Dustin.
So, one issue, as far as the GPS monitor and all that, they gave him a new device just now. They said it was a charging issue. They plugged it in, it would charge for 10 minutes, stop charging. He has a brand new one they just put on this morning. Now, the drug test issue.
Violation that he's out at 3 a.m.
Well, no, it's not that he's out, is that that's when it reconnected. So but they gave him a brand new device. So and they're saying there was an issue where they changed the device out and there's not a tamper on it. It's just, it said it was not receiving. They didn't say it was that he was out and about, it said it wasn't receiving, and they started receiving again. That's at least the report that I saw. It's not like they were tracking him other places.
Says here on 3/11/24, GPS device generated a failed to enter alert at 10:15 p.m. At 11:46 through 3:02, GPS device was in no GPS, no cell status and was unable to be monitored during that time frame. Client arrived home at 3:01 a.m. on 3/12.
So that's not when it arrived home, that's when it started charging again. Because it's not a geolocate. I mean, as far as I'm understanding, it's the GPS shows where he is,
I'm
not.
gonna be honest, Your Honor, that would be a question for pre-trial.
Oh, no, I'm sorry, it's pointed to the client, not to you.
Okay, I was like,
Saying out and that he's out in the middle of the night.
I don't think they're saying that. What they're saying is that it's received a no signal.
Client arrived home at 3:01 a.m. on 3/12.
Where was he before that?
Huh?
They don't know where he was before that. He was at home, he just wasn't charging.
You have.
That's the way I'm reading it.
Do you have,
Right
do you
there.
have the idea of where he is?
I don't see any notes from the case manager, and then at 10:05, I see on the report, it's showing that he's not at his home location. So I think that would be the fail to enter. And then there was the portable violations as well that were added. But again, from what we discussed earlier, I don't, necessarily have to go forward.
Portable violation in what respect?
They sent an email yesterday from the supervisor that was here earlier, stating that there were additional
Did Anthony send that?
No, it'll be from Cody Pittman.
Okay, so
This specific one is from Luis Galvan.
So I also have here, client was also instructed to obtain a portable alcohol testing device, comply with all testing protocols, refrain from alcohol consumption, and comply with all routine equipment service. The defendant failed to provide breath samples, scheduled times, resulting in 13 skips from 2/7/25 to 3/17/25. So he's still skipping tests. Come up, Mr. Jones. I just don't get it. I truly don't. It's over and over and over. You are still skipping tests. And I don't know what it is and what I need to do to get you to comply with bond conditions. You're still skipping tests. I mean, I have no other choice. I now have to revoke your bond again.
All right, well, then let's do a plea then.
Huh?
Let's plea it.
I agree with, and I'm okay, but I'm gonna tell you now that I want to have him TRAS'd immediately to see how we go forward.
Well, Judge.
You know?
Okay.
Just. All I want you to do is not kill anyone, man. That's all I want, you know? Really, I'm not asking for much. You have, since day one in our court, have repeatedly refused to comply with bond conditions over and over and over. And I'm not doing a plea to where he can just get out and just do, and
So,
you scare me.
so how do we resolve, Judge?
Huh?
So how do we resolve it?
So, yeah, I agree with you. I think that the correct thing would to do would be probation.
Okay.
But I would like to have him TRAS'd while he's in there. And I have a feeling I know what the TRAS is gonna say, and that's what I would like to do.
Okay. I would request you to set a bond.
Of course.
It's just costing him money, Judge. Already it's costing him is his family money.
So it's okay to just skip tests?
No, it's not. It's a test, but I'm saying
It's a
is.
skip. I might just be asleep, but I'm not trying to skip him wrong. I swear to
Stop,
God.
just stop talking. Yeah, you don't,
Sure.
just stop.
Okay, he goes with me. And it's literally, the minute he gets out, we have bond violations over and over and over. Now, what are we in now, day what?
If the court wanted to be made aware of the presumptive results.
What did he test positive for?
THC, Suboxone, Oxy, and benzodiazepines.
You tested positive for Oxycontin?
Yes, Judge, presumptively positive, it's being sent to the lab for the test issue.
Okay, bear with me 1 second, will you? I have Nathan,
Yes, sir.
come up, Ms. Lynch. She tested positive for cocaine and what else?
THC.
THC, Nathan. This is not my first bond violation with you. In fact, this is our third, and I don't know what we need to do to get your attention, but now I have to take you into custody again. She goes with you.
My stuff.
Yeah, I'll have them get it. I'm sorry, Nathan, but it's the third time. I can't continue to do it.
Okay, Judge.
So,
We'll take
she'll probably roll up on tomorrow's docket and then we can revisit it, like everything again, I guess tomorrow.
That sounds good, Judge.
Okay.
We'll be there.
Thanks, Nathan.
All right.
Judge, next is page 24. Spear, come on up.
Mr. Spears, you're charged with driving while your license is suspended. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
All right. On March 18th, officers on traffic enforcement at the Harris County Toll Road received an alert from the Harris County Transit Authority IMS system, which told them that a prohibited vehicle had passed through the South Hardy Plaza toll road booth. The public prohibited vehicle was known to owe an outstanding amount of $1,416. The officer observed the vehicle traveling southbound on the Hardy Toll Road and caught up with the vehicle and conducted a traffic stop. The defendant gave his license and informed officers that he did not have insurance. The driver's license came back as ineligible, and dispatch advised the defendant that he had advised that the defendant had prior convictions of no financial responsibility and had no driver's license.
Mr. Spears, I'm going to find that there's sufficient probable cause to go forward with your case. Can you run his license, please?
Yes, sir.
I just signed it. You're on probation in this court. You've now picked up a new case. I've now signed it. A warrant has now been issued for your arrest. You're now going into custody. It goes with you. Will you please appoint him a lawyer?
It is not eligible, Your Honor.
You're not to drive. I will have you sign an affidavit promising me that you're not going to drive. I don't care what's going on in your life. Unless you have valid liability insurance in your name and a Texas driver license, you're not allowed to drive. Do you understand, Mr. Spears? Don't send him down, Deputy Miranda, please.
Good morning, Judge.
Hey, good morning. Give me 1 second, James.
Is Mr. Gomez? Oh, yes, Judge. I'll
Oh,
give you a
John
second.
has another one in the holdover.
Yeah.
Oh, I see what you
He had two cases
Right.
and we've been conversing.
Okay, I'll call him now. Let me just talk to James. James.
Yes, Judge. Mr. Gomez came into court?
Yeah, he's here now.
Okay. Judge, he told me that there was a miscommunication. He wasn't aware of the time he was supposed to be in court, and that was why he had missed his court date.
Come on, Mr. Gomez.
I'm sorry, Judge. I can't hear anything. I don't know if you muted yourself.
I haven't said anything yet.
Oh, I'm sorry.
I'm looking at Mr. Gomez. You don't take things seriously. You don't take us seriously. You had your first bond violation report the beginning of March for failing to go take a drug test. And now a new one was filed because you now picked up a new case. We are going to do probable cause on your new case. You now stand charged with the offense of criminal trespass. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you. As you see, your lawyer is here with you on Zoom now. Please.
On March 19th, 2025, an officer was dispatched to an assault in progress, unknown weapon at City Plaza condominiums in Harris County, Texas. The complainant, a security officer, stated that she saw the defendant walking around the security office, which the complainant found unusual. The complainant stated the defendant went near the exit gate and was waiting for someone to come and exit through the gate. It was waiting for someone to come and exit the gate so he can get inside the complex. Complainant stated someone exited from the gate and the defendant got into the complex. The complainant followed the defendant and told the defendant that he needs to leave the property because he was criminally trespassing at the property. The complainant stated that she told the defendant several times to leave the property, but the defendant did not listen. The complainant stated the defendant laid on the ground, the defendant stood up, the defendant started taking pictures of witnesses, and the complainant came in between witnesses' motor vehicles, so the defendant could not take pictures of license plates. The defendant was identified by his Texas driver's license.
So at that point, do the cops come up there and they just arrest him there? Does it say? Does it take off?
Also, it does not state in the DIMS at what point he was arrested. Also, something that was missing from the summary was that a witness stated she saw the defendant punch the complainant and then they had a fight.
He punches someone.
That's what the DIMS states.
Mr. Gomez, I'm going to find that there's sufficient probable cause to go forward with your case because of your failure to comply your repeated failure to comply with your bond conditions, I now revoke your bond. He goes with you.
Excuse me, Your Honor, I'm approaching on Neil White.
Is he?
And Judge, he's been carried like since Monday, the 24th. That's when he appeared on your docket initially for a new charge for the bond violation report, which is filed, and also a motion to revoke and raise. But he was still incarcerated on Monday, Judge, Monday morning.
He's right here now, right?
He's here now.
Okay.
But
Come up, Mr. White.
Mr. White.
You were on bond for an assault of a family member.
Yes, sir.
Since 2023.
Yes, sir.
In 2025, in February, you pick up a terroristic threat. And now you've picked up another assault of a family member and a violation of a protective order. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On May 16th, 2025, in Harris County, Texas, officer was dispatched to an apartment for a family assault. Officer met with the complaining witness. The complaining witness had visible injuries on her face, including bruising on her eye and swelling on her head. Complaining witness went over to the defendant's house. Defendant grabbed the complaining witness by the arms and threw her into a table and chairs. Defendant began to punch the complaining witness multiple times in the stomach and slap her in the face. Complaining witness attempted to leave, but the defendant followed her through the apartment complex. The defendant currently has a protective order for terrorist threat, which bars contact between the complainant and the defendant.
Is that the violation of the protective order?
Yeah, it's a felony, VPO.
Your Honor, may I be heard? Your Honor, the complaining witness shows up at my client's apartment. He lives there by himself. She shows up like at 5 a.m. in the morning. My client did not assault her in any way. Actually, the complaining witness broke his phone, and my client left the apartment so he wouldn't have to deal with her because she wouldn't go away. But at no time, Your Honor, did he assault her. I did get to check out the videos, Your Honor, where the officers are interviewing the complaining witness. She alleges that he punched her in the abdomen. She is in absolutely no distress, Your Honor, when she's talking to the responding deputies. If he had punched her in the abdomen, Your Honor, I can really say that she probably would be doubled over and would want to go to the hospital. The EMS did check her out, it appears, but she refused transport to the hospital. I couldn't tell from the body worn cam video, Judge. It wasn't close up enough, but I couldn't tell. I couldn't see any bruises and it's like I said, she was not in distress whatsoever. She is the one who really went to his apartment. He did not go, he did not violate the protective order. And
The violation of protective order is a felony offense anyways, so.
yes, Judge. Yes, Judge. I understand. I understand.
So I just
And-
have, an assault, a terroristic threat, and now another assault.
Right.
So which assault is he alleging? That's the,
Right, Judge.
right?
Yes, Judge. And she's filed or the state has filed a terroristic threat on her behalf, a charge on her behalf. If she was so terrified of him, Judge, why is she popping up at his
I don't know
apartment?
that that's actually true. Who's saying, he's just telling that to you? I mean, how do we know that's really true?
Well, she's there, Judge. Those are the apartments that are shown on the body worn cam video. It's his residence.
Is she actually on video at his apartment? Have you
They're
seen
outside
it?
of the apartment. They're outside on FM 1960. That is not her residence. The protective order has got a totally different address where he is prohibited from
Tell me, Sebastian.
going.
Okay, well, the VPO is not based on an address restriction, it's based on the assault of a protected person. And as far as the representations that
defense has made today. We have no way of verifying any of that to be true. I disagree with the assertion that she shows no visible injuries. Her face does appear to be swollen with some red markings. Number three, the allegation that she's over at the house don't disqualify her as being a protected individual, and BPO is for an assault, not for a residency restriction. And at the end of the day, all those are fact issues, and what we're left with right now is the fact that in 2023, with a separate victim, he has an AFM, bond forfeits, then we have a terroristic threat with someone else, and now he picks up a separate AFM. And we can talk about how she's back all the time, but I think that ignores, first of all, the realities of domestic violence situations. And second of all, this isn't just one person that he's having multiple problems with. These are two separate people. So the state is going to stand on its motion to revoke and raise bail and is going to ask for 20,000 on all three cases.
Your Honor, may I respond? The complaining witness has not, has recanted to these March 16th, to the current charges, to the newer charges.
Which alleged victim is recanting, the first or the second?
The terroristic threat complaining witness, Your Honor. And the other assault family member case, Judge, the complaining witness is currently incarcerated. But
So which one's in jail?
so,
The oldest one is in jail.
When?
and
Or
You know, I'm not sure, actually. I have a colleague who spoke to her. I forget exactly what she's in for. She is in jail. As far as her recanting, I mean, that's,
is she in jail for something against him?
no, I don't think so.
And also, Judge, the complaining witness, the one that the protective order is on behalf of, she has not given a rip on the terroristic threat case, Judge. So something's not right. She doesn't want to.
Problem is
Tell the truth.
he keeps picking up cases. Stuff keeps happening to him. It's just, I mean, I fall down and I pick up a new case.
Yes, Judge, and I did.
Are we supposed to just let him go because he's picked up now a felony? You
I
know,
just wanted to relate to you, Your Honor, that my client does not have funds. He paid he paid to get out with his income tax return, Your Honor. He paid to get out on these two new charges. He paid to get his car because he was not arrested at the scene, but he was arrested thereafter while he was driving. They impounded his car. He paid to get his car out. And he paid because to get a new phone or get his phone repaired because complaining witness broke his phone on the date of the alleged incident. And I'm asking the court to leave his bond as is, or in the alternative, Judge, maybe he can borrow some. He's got $250 left from the income tax return. And if you could leave it, or $5,000, he could possibly do that, but not 20. He was in jail for an entire week, Your Honor, when he was arrested for this offense, for these new offenses.
pick up new cases. That's what happens. I have not asked you to do anything but be safe in my community. You're now working your fourth case. No, I don't want you to say anything. The only thing is that you continue to pick up new cases, and I can't just let you keep doing that without some kind of consequence. No, there has to be consequence to behavior, and the bill comes due. You can't continue to pick up new cases and expect good results. So I'm now going to revoke your bond. It goes with you. I can't. I have to show you that we mean business. Otherwise, we have no teeth. You know, what we say, it means nothing. I'm going to tell you now that I'm entering an order for protection in all these cases. And if you violate this, I can have a hearing to hold you at zero bond, and I will do it in a heartbeat to protect my city at all cost. If this person comes to you, you don't open the door. If they call you, you don't open the door. Or I'm sorry, you don't answer the phone. If they email you, you don't reply. But at some point, we have to say when. Now's that time. It goes with you.
Yes, Your Honor. Well, my bond.
You are on bond for DWI and you've now picked up a new DWI. Sir. You were charged again. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On April 24th, 2025, in Harris County, Texas, law enforcement officers were dispatched to a crash. The law enforcement officer spoke with a complaining witness who stated he had gone to the bathroom and heard the defendant crash into the bus. The complaining witness was the bus driver. The complaining witness estimated the damages to be $1,000. Another witness saw the defendant strike the bus, get stuck between the bus and another vehicle, and then exit the driver's side door and try to push the vehicle out. The witness stated after another individual told the defendant they were calling the police, the defendant fled. Another law enforcement officer was alerted to the incident and found the defendant, who matched the description given. A witness was able to identify the defendant as the individual driving the vehicle that struck the bus. Another law enforcement officer made contact with the defendant, who stated he was coming from an Astros game where he drank. The law enforcement officer observed a moderate odor of alcoholic beverage, glossy eyes, and profuse sweat from the defendant. The defendant refused to cooperate on standard field sobriety tests. The defendant refused to provide a specimen. A blood warrant was obtained and executed.
Mr. Gallegos, I'm going to find that there's sufficient probable cause to go forward with the case. I am now taking away your privilege to drive. You are not allowed to drive at all. Do you understand me? Yes, sir. On one ankle, I'm going to put a scram monitor so I know that you're not consuming alcohol. On your other ankle, you will get a GPS monitor, and I'm giving you a curfew because I don't want you out in the middle of the night. And if I find that you're out, I will revoke your bond and make it extremely high. He's on bond for this DWI.
Yes,
I'm
sir.
revoking his bond. You're going to jail today.
Right now?
Right now.
Okay, as far as the monitors, can we waive
So-
the fee?
Absolutely, of
Okay.
course.
Can you give my stuff to my mom?
Yes.
So these are conditions. We'll have him sign now. The GPS monitor prior to release.
Are you setting the bond?
Of course. Mr. Gallegos, I want you to understand something. This is an affidavit that you're going to sign to me, that you're going to promise to me you're not going to drive. I don't give a rat's behind what your excuse is. If Jesus comes from heaven and needed to ride to church, you drive. I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand? I am now also sending notice to DPS that I'm placing a restriction on, you're not allowed to drive, but I'm placing an additional restriction on your license that you are not allowed to drive any vehicle that doesn't have an ignition interlock on it. This notice is sent to DPS so that every single officer in the state knows that if you are in a vehicle driving, they pull you over, you don't have an interlock, they will take you to jail. Do you understand? As it stands, you are not allowed to drive for any reason. Okay, we'll have him sign this. We'll put him in back. Okay, Michael, are you ready? Jessica
Yes, Your
Taylor,
Honor.
come up. You are on bond for murder, and you've now picked up an assault case. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
Thank you, Your Honor. On April 27th, 2025, in Harris County, Texas, officers were dispatched to a disturbance/unknown weapon call. The complaining witness stated she is part of the nursing staff and that the defendant has been asked to leave on multiple occasions and refuses to do so. The complaining witness stated that the defendant was attempting to get her grandfather to sign over power of attorney to her, but the staff would not allow this due to the grandfather being diagnosed with dementia. The complaining witness stated that the defendant used force on the complaining witness to get her to leave the grandfather's room. The complaining witness states that the defendant put her hands on the complaining witness's face and pushed it back. The defendant was positively identified by the complaining witness and her Texas ID number.
You say that there was any pain? She pushed in the face. This is an assault, right? There has to be some kind of injury or pain.
She did state that she felt pain in the dim summary.
Okay. Ms. Taylor, I'm going to find that there's sufficient probable cause to go forward with the case. Now, you're saying there's a bond violation in this case?
Yes, it's in the.
Michael, have you seen this? And how did you already get appointed to this case?
Your Honor, I was appointed sometime very recently on this
How?
case. I received a text. I don't know what day it was, but I received a
It looks
text
like it
upon-
was the 29th, which was Tuesday. But how was he appointed a lawyer?
I'm thinking when she was in the holdover.
No. How is she, I mean, I don't understand. Well, regardless, I guess I'm glad that you're appointed because right now she's got bond violations. She was
I
ordered by the
wasn't aware
magistrate.
of that, Judge.
I'm sorry?
I wasn't aware of a BVR in this case. I actually have another BVR today before the court.
I know that, yeah, we got you. We'll deal with that one next, but you're on bond for murder. You were ordered by the magistrate to have a GPS monitor. You have violated those conditions. Unacceptable. I'm revoking your bond. She goes with you. No.
Your Honor, if I may,
Yeah.
Your Honor, she just was released because I met her in the holdover earlier this week, and she could not have been out of jail more than a day, 2 at the most. Would the court allow her to leave right now to get the device?
No. Did she not get the device?
There was a conflict, that's why the DVR was submitted, felony, so the magistrate ordered bond conditions, but the curfew times were not aligning with the felony conditions.
So what? I mean, you still have to abide by the conditions. I mean, what did they say the conditions were?
I have the paperwork right there.
I'm not asking you to say anything, Ms. Taylor. The only thing I want is I want my city protected. You're on bond for this serious case, and now you picked up an assault. I mean, you were ordered to have certain conditions. You must abide by these conditions. Good morning.
Judge, I'm approaching on Victor Jesus Rauda Lopez. And he's got a bond violation report, Your Honor.
Page 10.
Is he here?
He's here, Judge. He's in the jury box.
Speak English?
Yes, he does.
Come up. Come up. Did you get your GPS device?
Oh, yeah.
Okay. I'm revoking your bond. I ordered you to get a GPS device. You didn't get it. Okay, goes with you. Sorry, Maria. All right. We're gonna keep you. The bond right now is, oh God, it's 5,000 now.
I already paid the half.
1,001.
Yeah.
I'll just raise it up 1,001.
6,000.
It's 5,000 now,
Right.
so I'll just do 6,001.
Okay, Judge. 6,000.
So if he bonds out,
Yes, Judge.
you are on bond for criminal mischief. You've now picked up a new case. You now stand charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
The judge. On April 26, 2025, a law enforcement officer is on patrol and observed a motor vehicle run a red light and make a U-turn, nearly striking another vehicle in Harris County, Texas. Law enforcement officer observed the motor vehicle drive onto the curb of Richmond Avenue and initiated a traffic stop. The defendant passed multiple open parking lots and continued to drive. The defendant eventually pulled into a business parking lot. The law enforcement officer contacted the defendant and observed him to be eating fried chicken. The law enforcement officer asked the defendant why he didn't lower the window, and the defendant stated he didn't have any food and continued to eat. The law enforcement officer observed the defendant did not have a driver's license and was incoherent when asked to provide his name and date of birth. Law enforcement eventually identified the defendant by name and date of birth. The defendant continued to state, I don't have anything on the question about his whereabouts, and standardized field sobriety tests were conducted. The officer observed 2 out of 6 clues in the HGN, 5 out of 8 on the walk and turn, and 0 out of 4 on the one-leg stand. Due to the defendant, 0 out of 4 on the one-leg stand due to the defendant being unable to perform the test. The law enforcement officer noted that on the walk and turn, the defendant did not turn around. He stayed still for approximately 30 seconds. The law enforcement officer explained the one-leg stand, and after the instructions, the defendant began performing the walk. This occurrence happened again after the law enforcement officer tried to explain the one-leg stand another time. The law enforcement officer observed 2 unopened 6-packs of alcoholic beverages that were cold to the touch, and observed an empty fuzzball, and a 24-ounce can of Modelo beer and an empty Twisted Tea alcoholic beverage. The defendant refused both breath and blood. A blood warrant was signed and executed.
Mr. Juarez, I'm going to find that there's enough probable cause to go forward with your case. You said he doesn't have a license, right?
There's a number here, Your Honor. I'm not unsure if that meant that he did not have the license at the time.
Mind running it, please?
Yes, Judge. Your Honor, he does have an eligible driver's license.
I'm ordering you not to consume alcohol, illegal drugs, or unprescribed controlled medication. I've ordered you not to pick up any new cases, not to violate conditions of bond, and you have repeatedly done that. As a result, I am now revoking your bond on the first case, and you will go to jail today. And I'm going to tell you, you violate conditions again, I'm going to make the bond so high your head will be spinning. Do you understand? You're not to consume alcohol or illegal drugs, and I will put a scram on your ankle so I know that you're not consuming. Do you understand?
Your Honor, if I may,
Yes, sir.
on the first case, the court previously was testing Mr. Juarez 2 times a week, and he was doing pretty good on that for an extended period of time. In lieu of revoking his bond, would the court consider going back to bi-weekly testing?
Yeah. He picked up a serious case. He has alcohol in the car. I mean, he's allegedly consuming while he's driving, you know? I would figure that it's damn elementary that you're not to have alcohol in the car while you are driving. And there are multiple open containers, cold to the touch. No, I have to show you that we mean business. And me letting you go again when you have multiple violations, it's not going to happen. You go to jail.
Judge, you still have a big thing.
Yeah. Hey, who's teaching?
Judge Escamilla, he's here. He went for a drug test.
Okay. Come up, Ms. Escamilla. I guess Roxanne's not here.
She said that. So she did tell me alcohol or THC.
He's still using. Unacceptable. I mean, it's been, I tested you once, you test positive, tested again, you're still testing positive.
Judge, do we know the quantities and is it just THC? My client says he has not been smoking and I don't know how long it takes for it to come out of his system.
This case has been open since 2022. He's multiple times failed to appear. I've asked him to continually comply with bond conditions, and you've continually over and over and over and over failed to comply. Now your case is 1,010 days old, and you continue to test positive. Right now, you're going to jail. Goes with you. Unacceptable, Mr. Escamilla.
Your Honor, I've not been used.
Test says otherwise. And now at 1,000 days old, multiple tests, you stay with me. So the agreement that you guys have worked out is both, he's got 4 open cases?
He has 4 open cases, Your Honor. The agreement that we worked out was a time served on the failed to ID and the latest criminal trespassing, and they're dismissing a criminal trespassing and interfering with it.
No. Why, you need to understand something, that you guys can work something out. I don't have to accept the deal. And I am extremely upset with you at this point because I ordered you to get a device. You did not get the device, did you?
I'm sorry, I thought I was actually calling. I didn't know where to get it from.
I told you to get the device. I ordered you to get the device. You did not do anything. And now you are here on a bond violation, not to mention 4 open cases. And now you want me to just take a proverbial slap on the wrist? No. You need to understand, Mr. Musadabi, that actions have consequences. And you not only picked up 4 cases,
I brought my dad here. He's here. Can he come inside?
your dad has nothing to do with this and will not save you from this. You have 4 cases and you fail to over and over and over to comply with bond conditions. I will not accept this agreement, and I am now revoking your bond, and you will go to jail. Goes with you. Unacceptable. Unacceptable. You need to learn that actions have
I've been working.
consequences. You today go to jail.
Yeah, can we get a trial setting for Mr. Musadik?
100%. Happy to do it. But, you know, the 4 cases, I ordered him to get a GPS, just they didn't even get it. It's like at what point do we say when? We continually just